Hello friends. Today we're going to discuss about the Digital Personal Data Protection Act 2023. What are the roles and responsibilities on the healthcare industry under this legislation? I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be specifically discussing about roles and responsibilities on the healthcare industry under the Digital Personal Data Protection Act 2023. All the doctors, all the hospitals, or the group of doctors who are running the hospital, collecting the data, need to encrypt the data. They need to keep reasonable security guards. What are those reasonable safety guards? They need to have the network, which is having a firewall, which has antivirus. There should be a consent manager. They should be have a data protection officer, data auditor who will be monitoring the data. Access and control to the data is clearly maintained and monitored, and the security certificates are given, which are will be mentioned in the rules, and that need to be followed. And again, encryption technologies protecting the data during transmission and storage so that they reduce the risk of interception and data breaches. That means you need to encrypt the data not only while storing but also when you're transmitting the data for insurance purposes. You need to be very clear who will get access to this data, whether the doctor can access the data, whether he can retrospectively monitor, modify, or only prospectively he can monitor and modify, whether the nurses can only see the data, how much the data they can enter. Vendor security. That means security measure also to be will be held responsible for the data fiduciary, that is hospital and doctors. One of the data vendor, that is a person who is keeping the data in the cloud, should also will be abide by the law. And if there is any breach, the data fiduciary will be held responsible for those data processor if they are irresponsible. If you have hired electronic health record, cloud or third party vendors or softwares, or if you are using artificial intelligence, or you are using an hardware which is collecting the data, please make sure you have a valid contract, and that contract clearly says all these third parties will abide by the legislation in India, all the laws and regulation in India, not only prospectively, any new legislation which comes into picture, they will be held responsible for data breach which occurs at their end. And they will take the full responsibility and pay the amount if there is a breach on their end for the data protection board. That means the valid contract should clearly mention about the liability, responsibility, and how much they will pay if there is a breach. All the hospitals should hire the data protection officer and also have a mechanism and system in place. If there is any data breach occurs, immediately inform the data protection board and also the data principal about the breach. Regular audit and monitoring by the data auditor is very essential. At the same time, the hospital should not overshoot the consent. That means the hospital should they should make sure the data minimization is there and data purpose limitation is there. That means they have to take the only data which is required for treatment purposes, should not store the data beyond the time it is required. Like suppose NMC Act very clearly says that by the last day of the contact with the patient, after 2 years, the data should be removed. That means you have to remove the data. For example, if a telemedicine application is collecting the data, and when they're collecting the data, if they ask permission to contact list of the person or the patient, it is not allowed. That means you need to collect only the consent with regard to provision of services. Unauthorized access to the phone content of the patient will not be allowed. And you need to use the data legitimately. That means all the hospital should make sure anonymization, de-identification of the data should be done. If a pregnant woman is taking treatment and availing the prenatal services or perinatal services, antenatal services in the government institutions, the information can be shared with the others as per the law, but you need to maintain the anonymization. Only the number of people who are availing the services can be given, not the individual data. Be prepared. Need to have a comprehensive plan. If there is a data breach occurs, who are the people who are going to inform under the uh, this legislation? You need to do data privacy checks, monitor data auditing, and also employee training with regard to DPDP Act and how you need to maintain the security and privacy should be done. Now let's critique about this legislation. There are very important positive aspects of this legislation. This legislation upholds the privacy which is enshrined now under the Supreme Court decision under the Constitution of India. Consent of the data principle is very essential before you process the data. Special protection has been given to children and persons with disability. Penalty clause has been very clearly mentioned and it is welcoming. If the data principles gives false information or impersonate 10,000 punishment, 10,000 rupees punishment has been given. And this legislation also talks about alternate dispute resolution, which is very well welcoming. At the same time, there are negative aspects. Here, the government has been complete power with regard to owner of the data, and the government will not be held responsible if there is any breach occurs at the government end. The government has been exempted with regard to punishment, and the cross border transmission of data is not completely banned here. Of course, you can argue whether the innovation is given primary over the privacy. Invariably, the innovation at this point of time takes precedence. Whether it is right or wrong, over a period of time, we will come to know. And the Data Protection Board is not completely been told in the legislation and in the rules. It should not become completely bureaucratic. The people from the corporate world, the people from the civil society, and various startup people, the hospital, the people representing the various other sectors who are processing the data should be brought in under the rules and security measures to be taken. There are various conflicts with DPDP Act, RTI Act, various other legislation. They have not been cleared. That means in the near future, there are many cases which may end up in Data Protection Board. Finally, the purpose of Data Protection Act is to empower the citizen. But if the citizen gives false information, they can be punished under the legislation by 10,000 rupees. Whether it is right or wrong, you have to decide. To conclude, my dear friends, digital intervention is going to be here. At the same time, it is evolving rapidly. We need to engage the industry. We need to innovate. At the same time, we need to protect the privacy of the citizen. It is very difficult. Imagine if you want to live in this world and you do not want to use the internet. Is it possible? You may say, I am very concerned about my privacy. In this world, especially in the data world, is it possible to be private? It's a big question. And further, there are digital interventions like AI. They have their own biases, racial discrimination, geographical discrimination, religious discrimination that have not been addressed in this legislation. Further, unconditional acceptance, services on demand at the comfort of home will be the future. In such a scenario, you need to share your personal data. That can be only possible for innovation when this legislation is slightly liberalized. However, when this legislation is implemented and there is any conflict, all these seven important data principles should be followed. If you don't follow this principle, then the disaster is going to strike. To summarize, my dear friends, This law is applicable within the country and across the country. That means whoever is going to provide data, is going to provide services, who are selling devices, that the law will be applicable. Data principles have been given important rights and obligations. At the same time, data fiduciaries have been given certain responsibilities. At the same time, the government has kept lawful or legitimate use of the data has been given permission. But however, the government takes the complete power with regard to this legislation and exemption from any kind of scrutiny or else punishment. Although this legislation is balanced between innovation and privacy, over a period of time, this law be will be knowing whether is helpful or dangerous. And anyhow, the law is dynamic in nature. As and when required, the law will be amended. Thank you very much for giving your valuable time. Stay safe.